Good morning.
Morning.
Today's Monday, May 12th. I hope everyone had a great weekend, and all the mothers in your lives also had a great weekend. I don't know if you noticed, the number one request for Mother's Day is to be left alone. So, except as we get older, I think our mothers don't want to be left alone. They want to hear from us. But we have 4 cases on the docket this morning. 2 are set to argue. I'm going to be calling the cases. The 2 that I'll be calling first are the ones that are set to argue. If attorneys can please identify themselves and their readiness to proceed. The first case we have today is case number C240610-611, In Re MT.
Norma Wessels on behalf of the state, the appellant, we're ready to proceed. I'm also joined today by Ryan Chess. She's an intern with our office with the court's permission. She'll just be sitting at counsel.
Okay. Good morning. Good morning, both.
Jessica Moss on behalf of the appellee, MT, and ready to proceed.
Good morning. The next case we have is case C240543, State of Ohio versus Anthony Antolini.
David Hoffman for the appellant, Your Honor, ready to proceed.
Good morning.
Susan Zerfas for the appellee, also ready to proceed.
Good morning. The following 2 cases have submitted on their briefs. Case number C240438, State of Ohio versus Kenneth Kirkendall. Case number C240397, State of Ohio versus Tyrus Jones. Attorney Wessel, good morning again.
Good morning. I'd like to reserve 5 minutes, if I may.
Okay.
Thank you. May it please the court, opposing counsel. Before I begin, I wanted to first open it up to see if there's any questions immediately from the bench. Not seeing or hearing any. This case, the case of In Re MT, is specifically, as the state sees it, in judicial overstepping of the trial court's authority in dismissing a case solely at the request of the victim in this case, something that the Ohio legislature has deemed that the court expressly does not have the jurisdiction to do.
Well, this all began as a Rule 9 request.
Correct.
I think that that's been accepted throughout all the proceedings.
Correct.
And it's specifically discussed in the transcripts and so on. So it never was anything but a Rule 9. Would you agree to that?
In terms of how the request initially began, yes, that's correct. It began as a Rule 9 request. That Rule 9 was specifically denied by the magistrate before it was brought up to the trial court level. And both at the magistrate and at the trial court level, at least from the state's reading of the case, it seems to be as though the dismissal that the trial court went with was not based on Rule 9, not based on a determination of the best interests of the child, but specifically, as I read the trial court's opinion, sort of a assumption of authority, of some sort of inherent authority under Marcy's law to dismiss it because that is what the victim wanted in this case.
Well, I don't know if that's what it was, because the state from the beginning argued best interest. So the state was actually arguing best interest.
And when it was a Rule 9 motion, that's correct. As the state would have been required to do is make a determination, and as the magistrate would have been required to do, make a determination as to what is in the child's best interest in order to determine whether or not a Rule 9 was warranted. As we see it, a Rule 9 was not warranted. I think that's backed up by the fact that the Rule 9 request was specifically denied, and the magistrate said, instead of granting it in the best interest of the child, I'm only going to grant it based on the request of the prosecuting witness in this case.
Now, you're saying it was specifically denied, yet the entry does not reflect such. Do you agree with that?
I'd have to look back at I believe the magistrates does say the Rule 9 was denied. If it doesn't, at the very least, it was stated as much in the transcript. I don't have the magistrate's decision on me specifically, but I do believe that the Rule 9.
Well, let's go forward on the assumption that it's not in the entry then,
That would be fine.
because it's not.
Okay.
Okay.
I would have to look back to confirm.
So just
the
to
fact.
save you from,
If you look in the transcript, I wanted to make sure, but I
I think
won't
the
spend much
magistrate
time.
orally denied
I-
it.
that's, I
Yeah,
think,
it
the
just didn't
case.
make it into the written order.
I assume that is the correct.
So the judge's order references Rule 29, which everybody agrees was a typo, right?
That's correct.
So the judge meant that MT orally renewed his request to dismiss the complaint pursuant to Rule 9
Correct.
in the order.
Correct.
Okay, so Rule 9 is discussed by the judge.
I believe it is discussed, but in terms of the court explaining its decision-making, in terms of why it decided to grant the request to dismiss, again, I would frame it as granting the victim's request as opposed to granting the Rule 9, because there's nothing, as I see it, other than a brief reference to, Rule 29 F2D or Rule 9 in terms of its decision. Essentially as I see it, the court is essentially saying, if we put aside everything in terms of the analysis of the court's ability to dismiss solely at the request of the victim, it's not solely at the request, citing that statutory language, because there is that Rule 9. And I'll be clear for the court, I do think that the court could have granted the Rule 9. If the court had said, it was in the best interest of the child to dismiss this case, we believe, that in order to facilitate or to keep us out of any sort of court contact, that I believe dismissal under Rule 9 is warranted. I do believe that would be
Well,
within the court's.
that's where I'm getting a little hung up on where we are here, because if you think that there was enough below for the court to grant the Rule 9, does the court really have to explain itself? Couldn't the court have just said, Rule 9 granted, and then you can appeal that to us and we determine whether the record supports the Rule 9? How much does the judge have to explain?
Well, I'm quoting, and I believe I'm quoting you directly, Judge, when I quote the EK decision, where we're faced with something similar, where here we have a record where the court essentially is, as I see it, overstepping its judicial authority and just kind of resting back on its laurels when it comes to this fact that Rule 9 exists. This court specifically said, where the record is clear that a court gave no consideration to juvenile Rule 9A, the rule cannot serve as the basis for upholding a juvenile court's dismissal of a complaint on the other grounds.
Yeah, but EK, there was no Rule 9 even filed below.
I understand that.
Right, so that's the big difference, is that Rule 9 wasn't even in the calculus below
Well,
versus here.
And I think the distinction, to answer your question, is not just the presence of literally anything in the record that might possibly establish a Rule 9. I think there has to be a finding by the trial court directed specifically at the best interests of the child or the community, or a finding specifically to that Rule 9 and the reasons for it are warranted.
So the law requires that before a juvenile court judge can grant a Rule 9 motion, the judge has to make a specific finding?
I think so. I think there has to be, or at the very least, when it comes to the record in this case, I think it must be clear that that is the reason the court is making its decision.
But
Because
she says Rule 9 in her order. I mean, you're saying that just mentioning Rule 9 in her order is not enough, that she's got to make more findings?
I think there should be a finding that the rule, again, if there had been something to the effect of a Rule 9 granted, we would have, I think, a clear understanding of the court invoking its authority, which it's able to do. But here, not only is there nothing in the record as to the best interest, I mean, not in the record, but in the court's entry and its findings as to the best interest, the court specifically focuses on, the Marcy's Law, the invocation of Marcy's Law, its presumed understanding of the rights afforded to victims. To me, as I see it, it's essentially the court saying, I'm dismissing this at the request of the...
But it clearly says that the court cannot, under the statute, the court cannot dismiss a complaint alleging a child to be delinquent solely at the request of the victim and over the objection of the prosecuting attorney. So the court specifically, explicitly said, this is not based just on the request of the victim.
I believe that is what the court is saying, but that's not supported by the record at all. I think that for example, the court doesn't even address the fact that, at least orally, the Rule 9 motion was completely denied. I mean, as far as I see it, the oral dismissal of the Rule 9 motion goes directly to that lower trial court's findings of fact, conclusions of law as to what is actually in the best interest of the child. When we're looking at a reason for the court making its decisions, if there is something other than the request of the victim, I don't think it's in the record at all, and I do believe that it has to be. Otherwise, you know, when I read the statute and reference to the solely at the request of, I mean, certainly when it comes to dismissing a criminal complaint, or in this case, a juvenile delinquency action, there has to be something more that we can point to. I mean, if all solely means is that the court can broadly gesture to, well, you know, for example, it's raining outside, and because it's raining outside, you know, that's not, you know,
Well, that's
I'll
not the
consider
situation. I mean, the court goes on to say that MT orally renewed his request to dismiss the complaint. And there, in the record, there is support for a dismissal. Would you disagree with me on that?
No, I would not disagree with you.
Okay.
I think the reason the state has brought this appeal and the reason for that is, again, if the court had been more clear about its granting of the Rule 9, we wouldn't be here. But as I see the court's opinion, or the trial court's entry, it is essentially adopting for itself some sort of interpretation of Marcy's law that allows it to request or allows it to dismiss a case at the request of the victim. I'm not saying that the victim's desire for something to be the victim's desire for something to dismiss isn't relevant to a Rule 9. I do think that it is. But here, upon our review of the record, especially when you look at the court's findings and its entry, it seems as though the only thing supporting its decision is the request of the victims. If the court finds that to be true, that the only thing supporting the dismissal is the victim's simple request to do so over the prosecutor's objection, I think that's a clear overstepping of the judicial authority that was granted to the trial court by statute. If the court believes, and I don't think the record supports this, but if this court were to find that there had been a Rule 9 that was granted, then certainly I think that the dismissal could stand. But that's not, I don't think, what's
I
found
want to
in the
make sure I
court's
understand
entry.
where you're coming from, because the basis, the sole basis of your argument, as I understand it, is the basis of the dismissal. The basis meaning the rationale behind it. But you also agree that everything is really, was ultimately rooted in Rule 9, whether it was granted or dismissed by the magistrate, regardless of that all we have in front of us is began as a Rule 9 and ended as a Rule 9.
I don't want to misstate what you're saying. I think that would be correct. I mean,
Okay.
realistically, in terms of, I do not read the record to mean, I believe it started as a Rule 9. I don't think it ended as a Rule 9. I think maybe that's the issue that the state
So how do you
has.
think it ended? As a Marcy's law, is that what you're saying?
Yeah, I mean, I think the court's sole analysis.
But you don't think it ended as a 29? You think that that's more of a scrivener's
No, and
error?
I think Rule, and I agree with the, I think the appellant and the appellee agree that Rule 29F2D was probably just a scrivener's error and oversight. I think ultimately what the court meant to say is that there was reference to the Rule 9 motion.
Okay. So what do we do with the court's statement in the entry that it reviewed the magistrate's decision and it found it to be proper under the law and the facts of the case?
I mean, I think that goes to our ultimate decision about are you referring to?
In the entry, and I'm only referring because your argument is really rooted in the entry for the most part. Although you're talking about the transcript as far as the magistrate is concerned, but at no point was the entry requested to be modified. The state never went back and said, hey, this entry needs to be modified because the transcript reflects that the Rule 9 was dismissed, but the entry doesn't reflect such.
Yeah, well, and it was kind of a peculiar thing that happened in the procedure where we filed an objection, and then within the time frame where we would normally have to request a transcript or something like that, before there was no oral argument set by the court and there was no transcript. Essentially, before we got to the point where we would normally request a transcript in line with the court's briefing procedure, the court had already made its decision. It didn't wait for response by
Okay.
the juvenile or anything like
So
that.
that was why there was an anomaly there, because the court had relied on the, what do you call it, the tape, yeah.
I mean, presuming,
Recording.
we presume based on what the court put in its entry that that's what happened, that it reviewed as it would have been required to do, reviewed the transcript of the audio-visual recording of the hearing. But generally, the way that the juvenile rules are sort of anticipate things undertaking is, we file an objection, there's a procedure for us to request transcript. As I understand the law, the findings of fact are generally not adopted if there's an objection to a findings of fact and there's no transcript. But that's, as you've heard me say, we're not really objecting to, we have no problem with the facts as they were laid out to the magistrate. It just sort of, our issue is with the legal path and the procedure that the court took in order to reach its decision.
Could we,
I'm going to reserve the time, but go ahead
Yeah.
and, of
Okay.
course, respond.
I was just wondering, because you seem to suggest that there was enough below for a Rule 9 to be granted. Is there a way for us to be able to say that the juvenile court was right to dismiss for the wrong reasons? And that the reason was what was asked was the Rule 9? I mean, is that, because I'm trying to figure out practically where we're going to end up here. If you get a remand back and you say there was enough to dismiss under Rule 9, isn't the court just going to dismiss under Rule 9?
I mean, that might be what the court would do, but I think especially for something like that, this court needs to make clear,
That you can't dismiss just because of the victim?
Yeah, correct. The procedures to do so. I think given this record, I think it puts judges in a peculiar state where, like I referred to it earlier, as resting on your laurels in terms of, just kicking your feet back up and saying, look, Rule 9 exists, I can do whatever I want. But I think what's important here is that the statutes and the rules of the court are followed. I think that's the holding in the EK case and also the In re Arnett case, where there has to be that findings of fact. I do think that this court could send it back with instructions to, even to make more clear about why it was granting. I do not feel on this record that there's enough to find that the Rule 9 is what was granted. I think everything cuts against that. But I guess in terms of...
No, I know you're saying that, but do you think there's enough in the record that the Rule 9 could have been granted? Not that the judge actually granted it, but there was enough to support a Rule 9 dismissal.
The one judge that actually, as I see it, the one judge who actually reviewed the Rule 9 denied it. So it's difficult for me to say standing where I am, but I would say, Rule 9 is fairly broad. I'm not saying there's no evidence in terms of what could exist to grant a Rule 9. I think a court has very broad discretion to grant a Rule 9. So in that sense, yes. But again, I don't think that's what happened, because the only judge that did view it as a Rule 9, my reading of the record, is that they denied the Rule 9. So now we're left in the position that we are.
All right, thank you.
I'll reserve the rest of my time. Thank you.
Good morning, Your Honors.
Good morning.
Opposing counsel, may it please the court. This case is not a dismissal solely at the request of the alleged victims and over the state's objection. If this would have just been MT's mother and grandmother making the request, absent a request for dismissal by MT's attorney, then we would be in a different situation. And the court is only prohibited from dismissing this complaint if it's solely at the request of the victim. And the juvenile court did consider, at least in part, MT's dismissal under Rule 9. And I will say it is unclear, but the court considered this. And even when the magistrate in court said that she was dismissing the case, she also indicated several things on the record that confirmed what was raised in the Rule 9 dismissal, that MT had not picked up any new charges, that he had stayed out of trouble, that his mom and grandmother were happy with his progress, that he had been referred to services. She also wanted him to continue with the services that he was referred to, which again goes back to this whole Rule 9. But when
And some of those facts that you're sharing in your argument were reflected in the magistrate's entry, was it not, in the written entry?
that was not in the written entry, that was oral findings that she made in court towards the end of the hearing. In the entry, it only specified that the dismissal was at the request of the prosecuting witness.
Well, it says here, mother and grandmother report youth's behavior at home has improved, and he has been referred to counseling, and that's in the written entry. So that seems to be reflective of some of the facts that you're
Yes.
discussing.
Yes, and it was also said orally in court as
Yeah,
well.
there was also, and that's where we get into some kind of like issues, because in the transcript, it says Rule 9 dismissed. It seems to me, when I review the objections, that the state seemed to be moving forward at that moment as with the presumption that the Rule 9 was granted, because there's no discussion in the objection that the Rule 9 was dismissed.
The state raised juvenile rule, I think, 22 as well, at least in their objection, which is another basis that a complaint can be dismissed, as well as this Rule 9. But most of their argument premised on the fact that it can't be solely at the request of the victim.
Well, it's phrased a little differently here, which I find interesting. So I don't see anything in here in the objections that, at least in the written objections, that state that the Rule 9 was dismissed.
I don't
Oh,
believe.
hold on. Yeah, that it was in fact dismissed. They seem to be arguing standing, and then arguing the merits of the Rule 9.
Right. And,
Which they're not really arguing the merits of the Rule 9 before us.
right. And in doing this, when the magistrate made this decision and the determination in court, all was about this Rule 9. And the MT's mother and grandmothers wanting the case to be dismissed, and MT's mother believing that the case moving forward would be a hardship financially to her and her family, was in support of this Rule 9. It was not its own separate request. This is also not a situation where the state was utilizing its own discretion to determine whether to dismiss a case. When you look at the facts of the complaint, there's no indication of police observing any injuries, and so the state could have also only moved forward if MT's mother and grandmother were cooperative in moving forward with the case. So again, that looks to this bigger picture of what is in the best interest, what did the court have authority to do, and certainly the juvenile court has authority to control their docket and make determinations on whether a case should be dismissed. This case is very distinguishable from the EK case because here there was a request for dismissal under Juvenile Rule 9 and was considered. Factors for Rule 9 were considered by the magistrate, but also considered in the juvenile court's decision that they were not precluded from dismissing this complaint because this Rule 9 request was made.
So the magistrate orally denies the Rule 9. Are you saying that the written order is basically granting it? Or what happened to the Rule 9 in front of the magistrate?
While the magistrate orally denied the Rule 9, it did not end up in the entry, and the court only speaks through its entries. And so the entry was just a dismissal at the request of the prosecuting witness, but not solely at the request of the prosecuting witness. And there's other information beyond just the request of the prosecuting witness.
Okay, so you're saying we would,
Excuse me.
because the magistrate made certain findings at the hearing that would support the Rule 9 dismissal and doesn't include or denial, whatever, doesn't include the denial in the written entry, we would just construe the written entry to be a granting of the Rule 9? I'm trying to understand what your argument is with regard to the magistrate.
It's granting a dismissal, and the only request for dismissal was under Rule 9.
It could only be Rule 9, you're saying?
That was the only request at that point made in front of the magistrate. But
Okay.
then when the juvenile court judge reviewed those transcripts and then issued her own decision, that's where she also is referencing this Rule 9.
Well, she references Rule 29.
Yes, which was very clearly meant to be a Rule 9 because that could only have been the appropriate time. A juvenile Rule 29 would only occur after a determination on the merits of the case. So it clearly had to be a Rule 9, but she references that.
She kind of does it in passing, though. Like she gets into detail about Marcy's law, right? And that seems to be the basis of her decision.
I think that added to support for her decision, but that wasn't the sole basis, and that follows the statute of whether something is solely dismissed at the prosecuting witness. And we can look at the Rodriguez case out of the 2nd District, which looked at, for adult cases, for dismissals under Criminal Rule 48, what does solely at the dismiss of the complaining witness mean? And in that case, there were other factors beyond just this complaining witness to support that case being dismissed. And we get from the Bush case from the Ohio Supreme Court that there are many reasons why a trial court might dismiss a case. It's not a one-size-fits-all approach, and especially here, when we're looking at juvenile court cases, we have to make an individualized determination about the child. And here, the court looked at all of these different factors. So while Marcy's Law was referenced, and it may have weighed heavily on the juvenile court judge, it was not the sole factor.
Well, you know, I want to go back to the objections that are filed, because the objections are arguing standing and the merits. So, which is a little bit different than saying, oh, it can only be dismissed, or should not be dismissed only on the request of the victims or the witnesses. And as you've already pointed out, and everyone has pointed out, the trial judge talks about Marcy's Law. I'm trying to figure out what was that in context to? Was it because they understood it to be a standing argument and they were trying to establish standing, or what is your reading on what this Marcy's Law discussion is? Why this is here?
The court was trying to acknowledge that Marcy's Law does afford victims of crimes certain rights and abilities in court, and that the court was indicating that we should look at that and look at what a victim might be wanting, but it's not the sole basis. So it weighed highly, but it was not the only reason.
Okay.
So, in the judicial entry, towards the beginning, it says that the magistrate properly construed the facts and properly applied the law. But the magistrate's entry clearly says at the prosecuting witness's request. It doesn't say anything about any other reason. So I don't want to add words to what the magistrate's written entry says. So it seems like it's pretty clear that the magistrate's decision was solely at the prosecuting witness's request. And the trial court, again, said that the magistrate properly construed the facts and properly applied the law. What are we to do with that?
Because the magistrate also made these other findings that were beyond just what the MT's mother and grandmother said, it went beyond just the request by...
Well, where does that say that in the magistrate's entry? Again, I don't want to add words to it because
Sure.
the judge speaks through its entries.
So it talks about the dismissal at the prosecuting witness's request, but it doesn't say at their sole request. It doesn't use that word. And when the magistrate's decision is not final, so the juvenile court judge still has to review that and looked at all the transcripts of the case and looked at this juvenile rule 9 and whether that cushioned the decision from, or whether it would be precluded based on the statute.
So if I'm understanding you right, you're saying that even though at the beginning, the trial court said properly applied the law, are you saying that because again, it seems pretty clear to me that the magistrate was basing it solely at the prosecuting witness's request. So when the trial court said properly applied the law, we assume what I just said was correct, how do we get past that?
Properly applying the law and that the case should be dismissed. MT's in a situation where, because the case was dismissed, MT would not have filed an objection to the juvenile court judge about the magistrate's decision, and talking about the Rule 9, it was a dismissal. So it was only the state that filed the objection.
I understand that, but it was actually in more than one place that the trial court said that the magistrate was correct. The magistrate properly applied the law, and later it says the magistrate was correct. And I think, if I remember correctly, the part where the court gets into the discussion about Marcy's law is when the court says the magistrate was correct. And then it mentions the Rule 9 request.
And I don't know that the juvenile court judge needed to mention Rule 9 before talking about the additional Marcy's Law factors, but the juvenile court judge did consider the Rule 9. So that was clearly part of that determination. And when we look at, I know that the Arnett case out of the 3rd District was a Juvenile Rule 29 case. In that case, there was no factor similar to the EK case, specifically about what would be in that child's best interest. And here, there were those factors put on the record, was considered by the juvenile court judge.
Does the judge have to make specific findings in order to grant a Rule 9?
No.
So you think it would be proper for a trial judge, as long as the record supports the Rule 9, the trial judge could just say granted and
Yes.
doesn't have to make any specific findings of best interest or anything?
Yes, when you look at Juvenile Rule 9 and even Juvenile Rule 22A compared to Criminal Rule 48, Criminal Rule 48 specifically requires the trial court judge to make findings on the record. Neither of those statutes, or neither of those rules for the juvenile court rules require written findings. Now, had the state wanted findings of fact by the magistrate, the state could have filed a request for findings of fact and conclusions of law. The state didn't do that. They had just filed the objection.
So the way that we would review a Rule 9 grant is if the judge just says Rule 9 granted, and we would just then have to dive into the record to see if it supported the granting of the Rule 9.
Yes, then that would be an abuse of discretion determination.
Okay.
If you want to wrap up.
Yep, if there are no other questions, then I would ask that this court affirm the juvenile court's decision dismissing the complaints. Thank you.
Thank you.
Thank you. May it please the court once again. There's been some discussion about the court speaking through its entries, and there's been some back and forth about the state's position. So I want to read from the trial court's entry and be clear about what we're not contesting.
Okay.
It says the court was not barred from dismissing the complaint in this matter by RC 2930.06A4. I would tend to agree that, if there had been a proper Rule 9 motion that was gone through, that statute making reference to being solely done at the victim's request does not bar the court from dismissing it pursuant to Rule 9. I would agree with that. That comes after what Judge Bach, what I believe you were referencing, which is, to me, the court's analysis and its authority and the real reason that it dismissed the case, which was, again, making reference to the magistrate's decision. The court says, this court believes it to be in accordance with the spirits of Marcy's law to heed the victim's wishes in this case and to dismiss the matter without prejudice if the victims do not want to proceed with the charges. That is what the state disagrees with. The court does, in terms of whether the court believes it was in accordance with the spirit of Marcy's law, it is not in accordance with the letter of the law that it is required to follow. The court goes on to say, the court believes this to be consistent with the rights and protections afforded to the victims of crime by the Ohio Constitution and the Ohio Revised Code. It is in the interest of justice and in upholding the rights of the victim and the defendant that the court believes that the magistrate was correct. The state's position is that the magistrate was not correct. The trial court was not correct. The court does not have the ability, either assumed or through the Ohio Revised Code, to grant a request for a dismissal at the sole request of the victim. And pursuant to the record as we see it, that is all that happened here. Again, if the court had included on the record facts or findings, or if it didn't just treat Rule 9 as I see it as a passing afterthought, maybe we would be in a different position. But we have the record that we're stuck with here. And Judge Zayas, you had asked opposing counsel a question about, the state's position when it filed its objection, and what was the state doing. I think it's kind of part and parcel of the record in this case, where at the point we had filed our objection, not having the transcript ordered yet, we were faced with the magistrate's decision, which, at least as I see it, was, and I think it was clear to everybody at the time, just granting it at the request of the victim. So the state was trying to grapple with, does Marcy's law suddenly create standing to, does it make them a party to the case? Does it should Marcy's law be read to give them standing in an action such as this, or
So
what
do
is?
do you agree that you only argue it as a standing, or am I missing something in this objection?
No, I mean, I don't think your analysis. I would say the state's objection at the lower level, I think, was to the court's authority. Whether it was the court's authority or the victim's authority, it's sort of the jurisdiction of the court to grant something, which is, I think, in line with the objection that we made. I don't believe, unless anyone has any more particular questions, I don't believe I have anything further. All right, thank you very much.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. I hope you both have a wonderful afternoon and a great week. Good morning.
Good morning, Your Honor.
This is State of Ohio versus Anthony Antolini.
Correct. Sorry.
That's okay. Good morning, Attorney Hoffman. Would you like to reserve time?
5 minutes for rebuttal.
Okay.
Your Honor, thank you.
You can start whenever you're ready.
Okay, thanks. May it please the court, Ms. Surface, I'd like to confine my remarks to the claim regarding the instruction, jury instruction. And it was a plain error for the jury to convict Mr. Antolini of aggravated menacing after it was given a definition of physical harm and not serious physical harm. I'm relying on State versus Wolford, and in that case had very similar facts. The defendant in that case fired 3 warning shots with a handgun and ended up being charged with aggravated menacing. And in that case, the jury was given an instruction of only physical harm and not serious physical harm, and the Third District held that was plain error because physical harm obviously involves proof of a less serious harm, and it lowered the prosecution's standard of proof. And so serious physical harm requires significantly more serious injury, and the wrong standard constituted plain error, simply enough. And in this case, similarly, the jury was only given one definition to use for domestic violence and aggravated menacing, and that instruction was just physical harm. And there was a conviction for aggravated menacing, and it needs to be reversed, and then my client needs to have a new trial.
Mr. Hoffman, in the Wolford case, was it a plain error review?
Yes, it was.
Okay, thank you.
It seems like you're arguing that every time a court instructs on physical harm rather than serious physical harm, there's an automatic reversal. Is that what you're basically because
I think it's pretty true. If
Okay.
if the jury is considering a charge that requires proof of serious physical harm, and they're only given a definition of physical harm, I think that there would be error.
Because I in looking at the plain error, we have to look at whether there was a manifest miscarriage of justice and whether the proceedings, the outcome would have been different but for the error, right?
Mm-hmm.
And in this case, I can't remember, you can help me with the Wolford case about like what else there was involved in Wolford, but here we have a situation where the judge does tell the jury that it had to find serious physical harm.
Right.
He doesn't define it, but he tells them this, right?
Mm-hmm.
And then the state in the closing argument actually highlighted the difference of the burden of proof, and it said that the major difference here is in the serious physical harm as opposed to physical harm. And so the state actually, in closing, differentiates between the two. So I'm just wondering, with those added facts, if that would somehow affect your plain error argument.
Well, I don't think so, and here's why.
Okay.
With plain error, it's a three-part test. You have to have a mistake. It has to be an obvious mistake, and then it has to control the outcome.
Right.
And
So it was a mistake.
we got that.
We got that.
It's kind of obvious. I found it, so it must
Yeah.
be obvious.
Yeah.
And as far as the outcome determination, when it's a jury instruction, jurors are presumed to follow their instructions. I mean, they're told that the closing arguments are not evidence, and they're instructed throughout the trial to follow the instructions they're given by the judge. And Wolford is the only case I found where you actually had the incorrect instruction. A lot of cases have an omission of instruction. And in that case, you would look at the facts. You'd look at whether it could be proven anyway. You'd look at whether it was a dispute. If it was an element that nobody even cared about, then it wouldn't be outcome. But that's when there's an omission of an instruction or definition. In this case, you actually have a misleading, incorrect instruction.
Well, you
think
have
that-
the judge tell them that they have to find serious physical harm. He just doesn't define it, right?
Well,
He only defines physical harm,
yes, but that's what they've got. That's all they've got.
right? But
So
he's,
that's why I'm thinking it's misleading.
well, in Wolford, did the judge tell the jury that they had to find serious physical harm, or did he let them believe that they only had to find physical harm?
I think there were two mistakes in that case. There was the wrong definition, and then there was a definition of cause. And I think in that case, the judge instructed the jury that the cause was, he used physical harm in that. And so, yeah, that's a difference there. But, I mean, you had other mistakes in this case, too, where physical harm was, where the reasonable belief of the jury, if you want to look in the context of the trial and the instructions as a whole in this case, when they were instructed to look at the conduct of the defendant, they were told to look for physical harm and not serious physical harm, too. So there was a interchange of physical harm and serious physical harm with the definitions.
And the injury here was the fear of the prosecuting witness from being shot, right?
Correct.
Which necessarily would imply serious physical harm, right?
Generally speaking, yeah. So, yeah, but again, whether it would have been proven anyway as a consideration, like my opponent cites State versus Adams, a Supreme Court case. They look at that. But Adams was an omission of a definition of recklessness. In this case, you have the wrong definition, and so I hate to keep harping on that, but I think it's a big difference.
Well, wait, but wasn't there physical harm and serious physical harm involved in this case?
Yes, initially there were two charges that domestic violence called for physical harm, a threat of
Okay.
imminent threat of physical harm, and then the conviction was based upon serious physical
So
harm.
so physical harm was defined as it should have been,
Correct.
and then, so it wasn't a wrong definition, there was just an omission of the serious physical harm definition.
No, it was wrong because you can presume that they used that to consider that when they convicted him of aggravated menacing, and that was the definition they were given.
Under aggravated menacing.
Yeah, what they did was they gave both offenses at the same time, and then they listed
Then the
all
definitions.
Yeah.
Okay, so
And
the
so they had to
definitions
guess.
weren't given with each offense.
The
Okay.
definitions were not segregated between the offenses.
Well, that's why it seems more like an omission.
No, I would think it would be better. I mean, it would be up to them to pick and choose which definition applies to which offense. A lot of them have common definitions, but when you give both offenses and then list all the definitions without telling them which definition applies to which offense, I think that it's a wrong definition. It's not the omission of a definition.
But when the trial court was giving those instructions and stated the offense, did the trial court state the elements at that point?
Yeah, he read the statutory offense. He read both statutory offenses.
So it did say serious physical
Yeah,
harm?
yeah, he told him serious physical harm.
Okay, so that, but then later, when giving definitions, the trial court omitted the serious physical harm.
That's correct.
So it doesn't seem like the trial court said you need to find physical harm for the offense of aggravated menacing.
Not explicitly, no.
Okay, and again, when reading the offense, the trial court said the statutory definition of that offense, which includes serious physical harm. So it seems to me like it's more of an omission than a misstatement.
I can understand that, yeah. I can understand that, but I still take the position that if that's all they were given, that's all they had. They did come back with a question on that definition too of physical harm.
What was the question?
The definition of physical harm involves physiological impairment, I think, and they wanted to know what that meant. And there was no sub-definition of that, so they just were, told to do their
What does that
best.
mean? Yeah.
So if there are no further questions, I'd ask that the court reverse and remand for a new trial. Thank you.
Thank you.
Good morning.
Good morning.
May it please the court, Mr. Hoffman, we also take the position in this case that this was the omission of the serious physical harm charge for a lot of the reasons that were indicated in questions that were asked before. This case initiated with 2 charges. It was the domestic violence threat, 4th degree misdemeanor, involves imminent physical harm, fear of imminent physical harm. Then secondarily to that, we've got the aggravated menacing charge. There are numerous places in the record where those 2 things were separated out. The first place where I think the jury heard that was the testimony of Officer Hyatt. Officer Hyatt was the charging officer. Officer Hyatt explained to the jury the reason why he elected to file 2 separate charges in the alternative. So his explanation to that was, well, when somebody is afraid that they're going to be shot, they're afraid that they're going to be killed, and being killed is serious physical harm. And as a result of that, I filed the aggravated menacing in addition to the other charge. I think the problem with trying to rely on Walford is that Walford really doesn't get into a detailed analysis of how it came to its conclusion. And a better case, in our opinion, is going to be the 7th District case. That's going to be State v. Scott, and I believe Ms. Wood cited to that in her brief as well. State v. Scott does a great job of laying out a 3-part test that's a little bit different from there's a mistake, there's an obvious mistake, but in their 3-part test, the question is, did everybody understand going forward what the elements of this offense were? Was the court aware that there were separate elements in this offense, that serious physical harm was an element of the offense of aggravated menacing? Did defense counsel understand that? And did the prosecution understand that? And that's the first prong of that test. Then the second prong of that test is, did the state elicit testimony that met each and every element of the offense, and in this case of aggravated menacing? And then finally, there's the question of, but for failure to give that offense. And I think that we can apply this whether we're going with Mr. Hoffman's argument that it is the wrong definition, as well as whether we're going with my argument that it is the omission of a definition. But what was there an outcome that would have been different but for? And I think we don't see, and Walford doesn't get into that either. Walford really doesn't do a but for test in this, but we do see that in Scott. And in Scott, it was completely attenuated compared to the facts of our underlying case. In Scott, this was 2 sisters who were arguing, and one sister goes to the police and says, I'm going to buy a gun and I'm going to take care of business. And it was a third-party threat with the threat of a gun and no indication that she already had access to that gun. Now, if you take the facts that were elicited in our case, and you start, let's just start with step one. Was everybody aware that there was a difference between physical harm and serious physical harm? And in fact, the record's replete with that. It's replete with those conversations. And starting on day 2 of the transcript, the first couple of pages of that are defense counsel having discussions with the court and engaged in discussions with the prosecutor about the definition of serious physical harm. At one point, there's some indication that she's providing some definitions and jury instructions to the court. At another point, she has a co-counsel stepping in to provide some additional instruction. She was actively involved in the act of providing those instructions and describing them. And she, on at least 2 separate occasions, says, well, we're talking about serious physical harm because it's the aggravated menacing. And that's in the record. We can assume from the record that defense counsel was aware that serious physical harm was a separate definition for a separate charge.
So they were trying to get that into the jury instructions, and then somehow it just didn't end up in there.
Somehow it didn't make it into the jury instructions. As best I can tell from the colloquy that was happening was maybe the jury instruction they were using originally originated as an assault instruction, and they were just doing some copy-paste and trying to put the rest of those instructions in there. The next thing is whether the court was aware. Well, the court was aware. The court instructs the jury on the elements of aggravated menacing not once but twice. She stops herself, and then she goes back and she repeats that instruction. And that's also found on day 2 of the trial transcript. She reads off the entire complaint indicating serious physical harm for the aggravated menacing charge, and then she stops herself. There may have been some conversation at that point between her and trial counsel, and then she starts again and starts reading it, and she again reads the serious physical harm information. So the jury at that point has heard serious physical harm from the judge at least 2 times in relation specifically to the aggravated menacing charge. In addition to that, we have the prosecutor who, in closing argument, and I believe you pointed this out, in closing argument specifically says, the difference between these 2 charges is that for one, you have to find physical harm that was imminent, a fear of imminent physical harm, and in the other one, you have to find that she believed that there might be serious physical harm, and she also discusses, again, the gunshot, the being killed, the fear, the availability in her immediate presence within 8 feet of her during that last set of threats to the victim, that there were at least 3 guns within that vicinity. At that point, I think there's enough information being given to the jury that we can't say that the jury clearly lost its way and that there was a manifest miscarriage of
It
justice at
seems
that
to
point.
me, I'm really listening to everything that you're arguing, as I
Sure.
did with Attorney Hoffman. You know, and this all comes down obviously to the but for, the prejudice.
It does.
And it seems to me that but for will play out differently depending on what is the evidence that's being weighed and whether there's a weighing of evidence. In other words, a case in which you have like a he said, she said, and then you have the wrong jury, you know, the instructions are tainted by defining rather than serious physical harm or something like that, you know, but if there's a weighing, but I don't know if there's any weighing here other than the credibility of the witness.
I think there's a lot that goes to the
Do you understand-
credibility
do you
of the
understand what I'm
witness.
saying?
I do understand exactly what you're saying.
So I think that, but, you know, because really what Attorney Hoffman is saying is like, by its nature, if you're giving the jury the wrong information, that's what they're going to use. And so, you know, now the outcome is necessarily tainted. And of course, you feel otherwise. And it just seems to me that, you know, what in the case like this, where it really just came down to credibility, and that was it, you know?
I do see what you're saying.
There wasn't
I
like, there
think
wasn't
that-
any evidence on the other side saying, no, the harm was different or whatever.
Yeah, there definitely, the evidence consisted of testimonial evidence only. There were no extraneous evidence, there was no video of it, there was nothing else. And for this,
I mean, it
want
seems
to,
that seems to help your position.
again, look back at the 3rd District, right? Or, I'm sorry, the 12th District in Scott, where the testimony was the police officer talking about receiving this threat on behalf of the victim. So we had that third party. And in that case, the person making the threat, the defendant in that case, did not have ready access to a weapon. So what our jury in this case heard was that over the period of about 4 days, there were numerous threats. I'm going to kill you, I'm going to kill you, I'm going to kill you. I'm going to kill you is different than I might fire a gun at you. I'm going to acquire a gun when you have the knowledge that there are guns in the house, that there are guns in the vicinity of you. And it's a more direct threat. I'm going to kill you, I don't think can argumentatively be considered a minor injury at any point in time.
Was there ever any testimony that he said, I'm going to kill you? as
Yes,
opposed
I
to,
should kill you, I should have
should
killed
kill
you,
you.
I ought to kill you, I should have killed you in your sleep, I should shoot you, yeah, all of those things.
So there was testimony that he said, I am going to, rather than I should?
I should kill you. I believe the testimony as elicited from the victim repeatedly was a combination of I should kill you, I should have shot you in your sleep, I should have killed you, and I ought to kill you.
Okay.
And I ought to shoot you as well. That escalated then on day 4 of this altercation or verbal exchange between the parties. That escalated after the defendant had a conversation with his therapist, which the victim thought should de-escalate that, but instead it escalated it. And when he came back in, he was more angry. And this led to that the final point where she then left the house. Then we have the testimony of the officer. And the officer, of course, had no firsthand knowledge of any of these threats. But what the officer did have was a very, very upset and crying victim in front of him, which in his testimony he indicated increased her credibility to him and his concern for her safety, leading to that secondary charge of aggravated menacing and the alternative to the domestic menacing threat. So I do think that we have substantially more direct evidence of a direct threat of death to somebody than what we have in that 12th district case. And again, if we just look at the analysis that the 12th district went through, relying on the 3 Supreme Court cases, relying on the 12th district case.
You're talking about Scott?
Yes. and Scott.
7th district, okay.
7th
Just
district.
making sure.
Also relies on Tinchon, which came out of the 12th
Okay.
district. Adams, of course, which this court has previously relied on recently in Chastain, where the court neglected to give a definition of purposely on a sexual imposition case. And I believe 2 of the 3 justices who are presiding today wrote that Chastain opinion, which came to the same conclusion using this same analysis. And if we step through that analysis and we see all of the evidence, all of the testimony that the prosecutor elicited to apply directly to that element of serious physical harm, the statements, I'm going to shoot you, I'm going to kill, I want to kill, I ought to kill you, those statements go to serious physical harm and not to just physical harm. And I think that cannot be mistaken. And then we come to the question of, well, but for leaving out this jury instruction on serious physical harm, would the jury verdict have come out differently? And I don't think that we get there. I don't think we get there because the jury had so repeatedly heard killing, shooting, had the explanation from the police officer describing the difference between physical harm and serious physical harm, had the explanation of the prosecutor explaining those 2 things to the jury, and also had not once but twice hearing the judge giving that instruction and even though the instruction did not define serious physical harm, it clearly listed out the elements of the complaint and stated serious physical harm in it. So I think that there was enough in front of the jury to discern between serious physical harm and physical harm that is imminent, and enough to support that all of those elements were met beyond a reasonable doubt, that evidence was elicited. There's evidence in the record that defense counsel was aware and was actively involved in trying to create those jury instructions. With all of that, we ask that the judgment be affirmed in the lower court. Do you have any further questions for me?
Thank you for your argument.
Thank you so much.
I believe this, I had trouble understanding the Scott case, but as near as I could tell, I think that would be a situation where there was a complete omission of whatever it was they were trying to define, and I think it had to do with the third-party threat type of thing with aggravated menacing. When it comes to trying to discern the influence on a jury that the evidence had, I think it becomes conjecture, and I think that's why courts rely upon a presumption that jurors follow the instructions. And because, and I believe that even if you consider this an omission situation, the presence of the physical harm instruction was misleading. And when you have something misleading, then you can follow this presumption that the jurors follow the court's instruction and therefore had or used the wrong standard. And so for that reason, we'd ask that the court would reverse.
So in essence, you're asking us to find that it's presumptively prejudicial to provide a wrong jury instruction.
Yes.
Okay, thank you.
Thank you.
Thanks for clarifying that. Thank you both for your arguments. We're going to take the matter under submission and issue a timely decision.
Thanks so much.
Have a wonderful afternoon, and hopefully you'll have a great week. Although I hear it's supposed to be raining, I think, all week.
You all had a happy Mother's Day.
Thank you.
Thank you, that's very kind. And that concludes the proceedings this morning.